Welcome back everyone dito sa latest episode ng Deep Dive, a special FYI series. Obviously nakita niyo nagpalit na ako ng damit na mas formal kasi totoong luminary na kasama natin. Kanina we had an extra legal luminary, si Sir Ronald Llamas, the Machiavelli of the 21st century. Ang dami namin pinag-usapan. Now naman we have with us no less than former Senior Associate Justice Antonio Carpio. Thank you so much, Justice Carpio, for making time. I know you're a very busy guy these days. I saw the statement of Juan Sambayan. I'm quite familiar with your point of view. But Justice, I warned about this, didn't I? Like I said, marating tayo dyan. So it looks like our intel was correct. Now, Justice, before going to your point, particularly the statement by Juan Sambayan, which I'll go through, first of all, I'll just give an overview. So this is the so I'm not gonna go through the 97 pages, but basically ang argument dito ng Supreme Court is the process of impeachment is a constitutional and therefore legal process that takes place within a political environment. So the premise is on the legal process rather than its political nature. That it is sui generis does not, however, convert it to a purely political process isolated from the requirements of the Constitution as a whole. The basic constitutional mandate is that public office is a public trust. Being a constitutional value, any process seeking accountability of our public offices must take place within the strict framework and procedure outlined in the Constitution. Therefore, this court, regardless of this political result, will not evade its duty to declare when an act is done with grave abuse of discretion amounting to an excess of jurisdiction of any department, organ, or office. Now, the reason I had to emphasize this point is because now it's the Supreme Court being accused of medyo exceeding their jurisdiction. Now, Justice, there are a couple of different points raised by you and other legal luminaries. One line of counter-argument against this ruling is that it retrospectively comes up with a different definition or a new definition of what would constitute initiating an impeachment process per se. What is your read on that, Justice Carpio?
Well, there is a doctrine
Right.
of operative fact, and that is also called the doctrine of prospective overruling of
Right.
a decision. In other words, if there is a doctrine or jurisprudence or a law or a regulation, and that those rules, the laws were complied with at the time, and then subsequently that act that complied with the rules and laws at the time is being questioned now, and the Supreme Court decides that there has to be an additional requirement, an additional regulation. The doctrine of operative fact says, or the doctrine of prospective overruling is, you have to decide the case based on the rules at the time.
Right.
You can overrule the old doctrine, but it will be prospective.
Right. For the next
For the
processes
next, because
exactly, not retrospective.
Because
Yeah.
the reason is this. This is the way I understand it.
Right.
The basic principle of due process, you must be informed of what are the prohibitions, what are the regulations.
Right.
And if you do your act in compliance with those rules and regulations, then you cannot be deemed to have violated anything because you followed the law at the time.
Based on the precedent,
Yeah.
the doctrine that was there. Yeah.
Based on the existing rules and
Right.
laws at the time you were doing the act.
Right.
If the law or regulations were changed later on, the court cannot say, "Oh, you did not follow these new rules. How could
Because
you
it
have
was not
followed?"
there to begin with.
Yeah, how could you have followed it? So there is no due process because you were not informed at that time. You performed the act. The rules did not exist, so you were not informed. The important thing in due process, you must be informed that these are the rules.
Right.
There is a law. Either you are bound by the law because you should have known that the law existed. It doesn't matter as long as the law is there, whether you actually knew it or not. If the law is there, then you have to follow that. But if there was no such law and you perform an act without that did not contravene any law or regulation at the time, You cannot be said later on, oh, you did not follow because we're putting a new regulation now. It cannot be done. That is not
Unless
due
it's
process.
Asimov and we're in the
So that is the rationale behind the doctrine of operative fact. In the U.S.,
Right.
they call it the doctrine of prospective overruling.
overruling.
So
operative
now,
fact, yeah.
when all of these impeachment cases, when they were filed, there was never any hearing at the plenary level.
This is the idea that Sarah should have been given a chance to
Yes,
respond.
that
dun
they
pa lang.
should be have been
Right.
given a chance. There must be not an ex parte hearing, but an actual hearing,
Right.
and he should have been informed with opportunity to submit her own evidence. But that was not the rule at the time. There was no such rule. The world didn't know there was such a rule. None of us in the Philippines knew that there was such a rule. And all of these impeachment cases in the past did not follow that because that was not required at that time. And what was required at that time was that when the articles of impeachment or the complaint reaches the Committee on Justice, that's where
Right.
you are given an opportunity to be heard. That's where you can present rebuttal evidence. You can face the witnesses. And also, if it's a direct filing to the Senate, that's where you are given the opportunity to be heard.
Right.
Now, this new decision of the Supreme Court overturns that and says, no, you have to do it at the plenary level. Of course, nobody could have complied. If you use the present rule,
This
then
is the
all
Francisco
the
versus House
impeachment-
of Representative precedent, right?
yeah,
Yeah.
all the impeachment complaints at the time would be void. Against Corona, against Estrada, against Mercedes Gutierrez, everybody would be void right away. But of course, nobody could have complied that because there was no such requirement. So
Unless
that
you
is
have time travel machine.
Yeah, so that's basically due process. You cannot be bound by a rule that never existed at the time.
Right. Right. Therefore, you cannot be retrospectively,
Yeah.
retroactively
Yeah.
applying
So
this.
that's why under the doctrine of operative fact and the doctrine of prospective
Overruling. Yeah.
it has to be prospective.
For the next
Yeah.
impeachment
So
hearings, yeah.
they cannot retroactively apply it to the case of VP Sara Duterte because at the time there was no such rule.
Yeah. You're saying a requirement is being violated which was not there to begin with when the process was happening. So is this obstructing also the House basically also exclusive constitutional right to initiate articles of impeachment based on their own understanding of jurisprudence and the precedents?
Well, that's another matter, no? Because the Constitution says that the House shall have exclusive power to initiate impeachment cases. But the Supreme Court can intervene if there is a violation of a specific provision of the Constitution.
Right,
That's
right.
where. So that's why I said there is no violation because you cannot retroactively apply this new rule. What the
Right.
Supreme Court did was they retroactively applied it and said, oh, there's a violation. You see the point?
Right. The cart before the
Yeah, they
horse.
created now a violation by retroactively applying the new rule. You cannot do that. That is not fair.
Cart before the horse.
That's what Justice Ascun said. It's a matter of fairness. You can retroactively apply that rule and say, oh, you already violated that. That's how could you have complied with the rule that did not exist at the time?
And what about the Justice Panginiban's argument that this should have been given more time? Oral arguments, clarifications, para
Yeah.
medyo rushed. Some people even saying, bakit now sa gitna ng typhoon, meron pa yung holiday yung isang araw, ganyan,
Well,
ganyan.
I agree with the Chief Justice Panganiban because in all of the cases, constitutional cases, important cases decided by the Supreme Court, there is a petitioner questioning the constitutionality of an act of a government office or official. That government office official is always given the right to file an answer or a comment. And then most of the time there will be oral arguments. I mean, you have to give the other side, the government, an opportunity to present its side, a comment or an answer. That did not happen here. Two Cases were filed by Attorney Torion and VP Sara to her lawyers. And there was no order to the House to comment. What arrived was an
Right.
order to answer specific questions. So that's different. Specific questions, you only answer those questions. You're not being asked to comment on that entire petition. So
So parang clarificatory lang or something like that?
yeah, I mean those specific questions were very specific. Did you read it? Did you read? Did you have time to peruse the charges and the evidence? I mean, you were not asked to explain why what you did was constitutional. I mean, like every other respondent in a constitutional case, that was not afforded to the House. The first time that I know it happened. I mean, I've been there for almost for 18 years, and
2 decades, yeah.
yeah, the respondent is always allowed to file a comment before a decision is
It's made,
rendered.
exactly, yun nga eh.
You must be given a chance to comment, and if it's an important case, there's an oral argument before a decision is made. This is a situation where there was no answer that was
Na
required.
short-circuit yung process.
Well, I would say it's hard to justify that there is due process there. It's hard to justify. Because why was the House not given the chance to comment at least?
Yeah.
And that's the point of Chief Justice
Panginiban. Yeah.
I should have at least called for an oral argument because a lot of
Correct.
a lot of clarifications are made in the oral argument. Most of the justices decide the case based on the oral arguments because that's when you see the entire picture. Your questions are answered by either side. So, but okay, it's not really necessary. But at least what is necessary for me for due process is there must be a comment or an answer. There was no comment or an answer.
We will go to the motion for reconsideration part of this discussion soon. But the reason why I mentioned kanina the emphasis on the legal nature of this, although it is within the political environment, is because you have argued, Justice CARPIO, that this is clearly a political process before it is purely legal process. Is that a proper understanding of your argument?
It's sui generis. It is both a political and a
Right.
legal process.
It's a hybrid siya.
It's a hybrid.
It's a hybrid, yeah. So therefore, you feel that there has been an overemphasis in the legality of this process rather than its hybrid
No,
nature?
what we should look at is there a violation of the Constitution? That's basic. Because this involves a constitutional issue. When the House exercised its exclusive power to file to initiate the impeachment, did it comply with the Constitution? That's it.
That's it, yeah. That's the fundamental
Yeah,
question.
my appreciation of the facts as told to me is that they complied.
Let's talk about so this is really the crux of your argument. I mean, this is in the one sambayan statement. You can already see that. So the Supreme Court's decision, according to the statement, incorrectly states that the fourth impeachment complaint was filed out of time and transmitted to the Senate without plenary action. House records, however, show that the fourth complaint was filed on February 5, 2025, before the adjournment of the House of Representatives and before the dismissal of the first three complaints. And then key facts were mentioned here, including the transmission of the fourth complaint to the Senate at 4:57 p.m. and the House of Representatives adjournment at 7:15 p.m. Therefore, the position here is that the Supreme Court's decision rests on a flawed understanding of the timeline and procedural actions taken by the House of Representatives. Can you explain that further, Justice?
Yes, because the the articles of impeachment as signed by more than one-third of the members of the House were submitted to the Secretary General on February 5.
February 5, yeah.
Yeah. And the Secretary General administered the oath to verify it. Because the House says that the resolution of the signed by one-third must be submitted to the Secretary General. So they submitted it there. And according to the information relayed to me by the lawyers of the House, that the plenary approved it. There was a motion to approve the resolution that was signed by more than one-third of the members of the House. It was approved to be adopted by the plenary. And after that, the next step was they moved to archive the 3 prior impeachment complaints, and it was archived. And then the articles of impeachment were sent to the Senate and received by the Senate at 4:57 p.m.
Right.
Just before 5 p.m. And at 7:15 in the evening of that same day, the House adjourned.
Right. So
That's in the time stamp
Right.
of the minutes of the
Right.
House. So, and then the decision of the Supreme Court says the 1-year bar period started to take effect upon adjournment. So upon adjournment, you cannot file any impeachment complaint of the same nature
Right.
against the same official. But they already filed it. Filed with the section and approved by the plenary before
The
adjournment. So it's within.
Yeah.
So I do not see why the Supreme Court would say that it was filed out of time.
And also yung how you count, right? Yung parang day 0, the next day pa yung count.
Yeah,
like
well,
even the 1 day, exactly.
Yeah, because
You-
the calendar day is different from session day. There are
Right.
only 3 session days in a week: Mondays, Tuesdays, and Wednesdays.
Right.
And if the House has a session on a Monday and they do not adjourn it, they say we suspend the session until tomorrow.
Right.
When they meet the following day, that is still one session day because
Exactly.
they just suspended
Exactly,
it.
yeah.
In the legislative calendar, they can stop the clock. That's basically it.
Yeah.
So when you cannot count calendar days when you're talking of the work of Congress, the Senate, or the House. It has to be session days. And session days are not 24 hours. They could go beyond, depending on whether the session was adjourned or suspended. If it was suspended, it continues. The session continues to the following day, and that's just one session day.
And that's just one, exactly. Yung counting
And
din-
that's why the lawyers of VP Sara said it exceeded already the 10 days because the Constitution says the impeachment complaint must be included in the order of business within 10 session days from receipt. So, but those 10 session days are not calendar days, and they are not 24 hours. They could extend depending on how the House adjourns or suspends the session.
Was this clerical error, misunderstanding of the procedures,
Well-
arithmetical problem? What's going on here, Justice?
Well, that was it was the lawyers of VP Sara who said that it exceeded the 10 days.
And the Supreme Court bought that.
Bought that, bought that.
Bought their arithmetic, basically, of counting
Yeah.
it.
So I said everything is on record. They can
Check it, yeah.
Because they asked the House, did you comply? Because that was the allegation of the petitioners.
Right.
And the House said, yes, we complied. And the House explained why they stated the dates. These are the session days, and it's on the 10th day they filed the resolution signed by at least one-third of the members of the House.
Yeah.
So they said we're on time, and they even did beyond that. They adopted that resolution. The plenary, the entire body, adopted that resolution, and it passed, of course, because more than one half signed it.
Alam mo, I'm looking at the comments now. People are like even more outraged after your explanation of like, oh, what happened, Vela? Like, what's going on? ¿Qué pasa, right? Because, I don't understand bakit hindi nila hinintay yung oral arguments, clarification. Why did they necessarily just bought the Sara team's version of the arithmetic of, the days counting? Why is the definition of yung initiation of the impeachment process parang new doctrine? Why was it released in the, there's so many questions coming out. So basically, what is the next question here? Motion for reconsideration? Is that the
Yes.
natural next step?
Yes, I hope that the House will file a motion for reconsideration, and I think the Speaker already said that we are filing, and they will file that, and that's the normal course. You file a motion for recon, and if you can establish that the 10 session day rule was never breached, you file it on time, and this is really, you're giving it retroactive effect. I think the Supreme Court will do the right thing.
So they'll look at the facts again and try to correct it because they're not sacrosanct. Like no one's perfect. It's still a fallible
Yeah, I mean,
institution.
we are not omnipotent.
Yeah.
We are not
Unless you're
perfect.
Ronald Llamas, obviously, but
So, I think, and this will enrich jurisprudence. We clarify everything. So I
Healthy
think this
debate.
will turn out for the better for everyone. As long as the House will file that motion for recon, it will be clarified. And the House will open its record, of course. I mean, if what they're claiming is really correct, that they actually voted to approve the resolution.
right.
The plenary voted to approve the resolution before they adjourned, then that closes the dispute. I mean, it's very clear.
So where does that leave the Senate? Because there are multiple arguments coming out. One is saying that the Senate should just respect this, otherwise they're going to trigger constitutional crisis. Some are saying Senate has the sole constitutional prerogative on this matter, so if they go with it, then they should go with this. And then there are ideas about off-ramp, some sort of off-ramp here. One off-ramp is, well, if there's going to be a motion for reconsideration, it's not final, so the Senate is not creating a constitutional crisis. Another idea is that, no, wait for the motion for reconsideration and then wait for the response to that, and then the Senate can move forward.
My suggestion is, since the motion for recon will be filed, the Senate should just wait.
Should just wait.
Yes, should just wait to show respect for the process. It doesn't mean that they are conceding or weakening their exclusive or
Constitutional,
exclusive
prerogative,
power
yeah.
to try and decide. They have that. That's written in the Constitution. But I mean, let's be sober about it. Let's wait for the Supreme Court to decide.
And speaking of let me sober again, that's why the other day I made a statement. I said, I know there's a lot of frustration, there's a lot of attack here and there, and as I said, I hope, well, it is true that, Duterte appointed most of the justices, but that doesn't necessarily you shouldn't make inferences based on that. But speaking of that, sabi ng iba justice dito, dapat ma-contempt daw tayo for questioning. How dare we? What is the jurisprudence around the contempt idea? Si Sir Ronald kasi was saying, okay lang daw kung yung 3,000 lang at saka hindi naman siya abogado, so
Well,
6 months community service ba?
Well, freedom of expression.
Right.
Yes, we can talk about this because it's a matter of national interest, transcendental importance.
Justice Pangilinan used the
this
same
is
term,
a constitutional issue.
Yeah.
We can talk about it. There's nothing private about this. The decision is out. We can comment on the decision. And we're respectful about it. Let the process continue. Let the House file its motion for recon and Senate just wait for the decision. I mean, there's nothing contemptuous about that.
Right. So last part of our discussion, Justice. There are also a couple of questions. One question is, bakit next February pa? Bakit hindi next December? Kasi yung first complaint was filed in December. Bakit hintayin mo? Bakit February yung fourth complaint yung basis for cutoff point?
Well, because according to the Supreme
Not
Court,
effectively dismissing first
yeah,
three.
yeah, the first three were dismissed
you count the
effectively
four lang, yeah.
on February 5th, 2025.
So you just count the fourth.
Yeah.
And then, what about the notion of People's Tribunal to simulate what should have? I mean, just in case the motion for reconsideration doesn't lead to a reconsideration of the decision, is a People's Tribunal one way of continuing this process of asking for accountability, simulating what it could have looked like?
Well,
what is your thinking on that issue?
That will not have any legal significance.
Right, hindi siya,
and
forcible.
besides, I don't think it will be the end of the world if we wait for February 6th of 2026 for a new impeachment to be filed. I mean,
Yeah, just to be clear, and to be fair again to our Supreme Court, sabi nila, our ruling does not absolve petitioner, Sara Duterte, from any of the charges. Any ruling on the charges against her can only be accomplished through another impeachment process, followed by a trial and conviction by the Senate. Diba? So, but they were very clear. However, any new impeachment complaints against the Vice President can only commence in accordance with this decision no earlier than February 6, 2026. So, hindi sinasabi ng Supreme Court na walang substantive basis for the impeachment trial. What they're saying is that this is our idea in terms of procedural, irregularities, and therefore you do it next year. Kasi sinispin din nung kabila na, ibig sabihin wala nang kasalanan, wala pala nang kalokohan lahat to, di ba? So I think this is also a very important clarification by the court. So we have to be fair to the Supreme Court. They said this ruling does not absolve petitioner Sara Duterte from any of the charges.
Yeah, because we're talking only of the validity, constitutionality.
Right.
We're not talking of the merits of the case.
Exactly.
So, if the Supreme Court says, no, we're not changing our mind, well, everybody will have to wait until February 6, 2026.
Right.
That would be the meaning of that. But I think if presented with the facts, the Supreme Court will decide correctly. That's what I'm saying.
Right. In coming hours, President Marcos Jr. is going to give his State of the Nation address. Should the President say anything about this, or how can he say nothing about it but saying something about it? Like, where does the President stand? Because he represents the executive branch. I mean, now we're seeing different pillars of the state are kind of somehow at loggerheads. What should the President do to diffuse the situation?
Well, he already issued a statement that we should respect the decision of the Supreme Court, because I would say that, yes, the Supreme Court is the final arbiter
In terms of interpreting,
interpreting the Constitution, but it does not prevent us from explaining to the Supreme Court that these are the facts. That's
and to
what
reconsider it.
To reconsider it.
Accordingly. Justice, last year, our year-ender was our fear of extra constitutional forces gaining momentum if there's systemic dissatisfaction, for the lack of a better term. Sa tingin nyo ba, etong mga nangyayari ngayon, ano bang kailangan mangyari na hindi tayo mapunta doon sa mga medyo mas delikado na mga scenarios? Ugly scenarios whereby sabihin ng tao, kasi everyone is attacking, if you're on this side, attacking mo yung House of Representatives and the President. If you're on this side, attacking mo yung Senado or Cheese and then yung Supreme Court. Like, this is not good for a democracy, right? At the end of the day. That's my worry. Like, I mean, I have my own understanding of things, but at the end of the day, ang pinaka-worry ko is, I don't know, Justice, if you follow the situation in Brazil, right? Remember there was that Operation Car Wash thing? Next thing you know, the President, the Vice President, later even the DOJ, the prosecutor, everyone got ensnared in one sort of scandal and another. The whole Brazilian democracy was in total fracture, right? So my fear is, if there's no proper constitutional off-ramp here, and this mudslinging and polarization and disinformation, and mutual alienation continues. And that's why I was asking folks, please let's not attack the justices, etc. Yes, some of us were emotional at first, but I immediately said, let's be very careful because if we keep on escalating this, you might just pave the way for people who don't believe in any kind of rule of law and go completely for something like RevGov or something like that. What is your sense on that front, Justice?
Yeah, that's precisely why I'm saying that the House should file a motion for recon
Right.
and probably call for, the Supreme Court can call for oral arguments. And so the facts can be established because we have to start with the facts here because this is factual. Was there a violation of the 10 session day rule? Was there a breach of the 1 year bar rule? These are all factual.
Right.
They're based on dates. So I think we can decide this to the satisfaction of everybody if we know the facts.
Right.
So I think it's important that there will be a motion for recon and there will be oral arguments so that everybody will be satisfied that both sides were given an opportunity to be heard.
Right.
And that's why I'm saying that the House here, since they were not given the chance to file an answer or a comment, the Supreme Court should call for all our arguments in this motion for recon,
Exactly.
at least to satisfy their side, that they were given all the opportunity to be heard. So, and I think that's why the Isang Bayan has been filing cases before the Supreme Court. We question the constitutionality of confidential funds, the General Appropriations Act, because we want to be all of these disputes to be settled peacefully and legally and not result in a revolutionary government.
Keep the guardrails, the
Yes.
legal guardrails.
So we can say that we did everything in accordance with the Constitution. So the Supreme Court has said its final decision. Let's just follow it because that's how we preserve peace.
And in that sense, we are on the same page as, Senior Associate Justice Leonen, that we, at the end of the day, we want the rule of law to prevail, right? It's just that we have different interpretation of facts and doctrinal application here. Justice, I don't know if you were updated on the whole Baste versus Torre fight, but narinig mo parang blind item tayo ng isang senador.
Tapos ngayon, gano'n na, meron pa tayong isang, how do I call him? Kolumnista.
So nung una parang ikaw yung tinamaan, tapos ang may awit naman. Justice, what are we doing here to elicit such a eloquent riposte from some of our good senators?
Well, what we're doing is really just to clarify the issues, and I hope I've been able to clarify certain issues. But at the end of the day, we understand that the Supreme Court is the final arbiter.
And we respect that.
And of interpreting the Constitution, we respect that. And that's the reason why I've been telling everybody, no, you don't use violence, you don't use armed force to settle a dispute. Let's go to the Supreme Court. Ask for a ruling.
But should there be a public mobilization, at least pressure, rallies, something like that?
That's part of
Democratic exercise.
Freedom of speech, the freedom to rally, that's in the Constitution. So we respect that, but no armed violence because that's not allowed.
Of course.
I don't think we will progress if we keep on using arms to settle disputes. If there's a dispute, there's a final arbiter, the Supreme Court. But we can exhaust all means up to a motion for reconsideration.
Within the guardrails. But one of the justices nag-inhibit siya. Why would that be the case?
Well, there are many grounds to inhibit. So,
Such as?
Yeah.
Conflict of interest?
I don't know the grounds. I have not...
but that's an interesting. Like people are saying, bakit nag-inhibit yung isa, diba? Oo. So,
well, because he could have been consulted when he was still in the private sector, in government, on the issue, and he didn't want to be biased about it.
It's a prerogative. You can just say, I'll self-inhibit na lang on that front. Well, Cheese is not gonna inhibit himself.
I've done that also. I've inhibited.
You have inhibited yourself.
I've inhibited.
And last point, by the way, Justice, so many people are watching from all over the world. I mean, like our friends and followers and all. May isa pang tanong, meron ba tayong nagkaroon ng precedents kung saan yung Supreme Court reconsidered the earlier decision and accepted na nakamali sila or something like that?
Yeah, so many times already. Yeah,
What are examples, for instance? Like,
well, for example, in the mining case, Labugal,
right.
there are many cases where the Supreme Court.
That's why it's not impossible to imagine them saying, okay, in consideration of new, facts, corrections, whatever, we will reconsider.
And I
this.
think there's a special reason for this here because they were not given the opportunity to file a comment or an answer, and I think that's very material.
Yeah, just give it. So that will be the Congress sending people there to make that clarification.
Yeah,
sa oral
the
arguments.
lawyers of the Congress will have to of the House will have to represent.
Right. On that note, thank you very much, Justice Carpio. Actually, this was really illuminating. Everyone really enjoyed this discussion. We're hoping to also interview the other justices that we mentioned kanina. But Justice Carpio, really thank you because I know your heart. By the way, walang kinalaman yung kulay na pink ng ano. It's just the shop lang malapit dito. I know your heart is in the rule of law, fundamentally, right? Because no matter how frustrated we are, no matter how unhappy or dissatisfied we are with everything happening, don't forget that we have to operate within the constitutional parameters. Otherwise, you're inviting unknown evil, right?
Yes. Otherwise, we don't know where we'll end up.
Exactly.
We can only continue to progress if we follow the Constitution. And I think that's the way to keep the nation united at least. And we have to proceed on one direction. We may have our differences like this, but I mean, this should not divide the nation.
Exactly. And what gives you seem to be a very cautiously optimistic person, Justice. Where is that coming from? Is it the good Vietnamese cafe? Where is this coming from, Justice? Because the other people I talked to seem a little bit more agitated. Sir Ronald Llamas had his own take on things. You seem constantly very cautiously optimistic on things, Justice. Where is this coming from? Is it a temperamental thing or is it an experiential thing?
Well, I've been in the Supreme Court for almost 19 years, and we've gone through a lot of really serious problems, a lot of difficult cases reached the Supreme Court, but we're still here. I mean, we're intact, and we will overcome this.
Right.
And whatever it is, it's just a postponement up to February 5.
It's not the end of the world, yeah.
It's not the
Assuming
end
the
of the world.
motion for consideration will not
Yes,
be,
I mean, in the worst case scenario, the impeachment will proceed. It's only delayed, but we want to do it right because this will affect future cases, future impeachment, and it looks like it's so tight now, especially that if you have to hold hearings at the plenary level and you have only 3 session days, it's impossible. I mean, nobody will be able to file an impeachment case and succeed because of the 3 session days. It will be difficult.
So that could tie the hands of the
Yes.
HOR in terms of exercising its
Yeah, so
constitutional
we have
duty,
to. That's why we have to go through this and ask the Supreme Court to take a second look, because it's not only this case of VP Sara. I mean, this will affect future cases, and I think that limiting it to 3 session days, you have to hold a hearing at the plenary level. You debate on whether to prepare the draft of the articles of impeachment. You discuss it, deliberate, and vote for it, and call for a hearing. You can't make it. So I think we have to. I think that's the big problem. Not only this case, but future
for
cases.
future one.
Yes.
Yeah. So you're making it even more difficult. On that note, thank you so much, Justice Carpio, for spending your weekend with us. More power to you. Please take care of yourself kasi mahaba-habang usapan yan. Next thing you know, February 6, 2026, we still have to continue this discussion. And may mga nagsabi, baka magkaroon ng Quadcom 2.0. I mean, we don't know. A lot of things that could happen, right? It's not unconstitutional, right? I mean, the HOR has that prerogative. So marami pang exciting things na mangyari. So on that